was cool, though.
It was.
'Cause you did a lot of things.
We did.
There were 80 recommendations.
Yeah. All right, we'll go ahead and call this meeting to order. Good afternoon, everyone. Hopefully, folks have had a chance to look at the minutes from the previous meeting. If anyone has any edits or addition, now is the time to say so. All right, seeing none, I'd entertain a motion to accept the meeting minutes as given. May I have a second?
Second.
All in favor, please raise your hand. Perfect, thank you. And now to the Inspector General for an update.
Well, I will say good evening. I will send you the update. We have been just really swamped with, we got requests for the board. We just finished that up, so you all should have gotten that in email. I will send the update later on. I apologize, just working with the, it's also the end of the year for CPD, so we get a lot of requests for documents. So just didn't get a chance to finish everything and verify it, so we will definitely send that out later on this week.
Perfect, thank you. All right, next up, I do have some good news. We have a new board member who will be joining us, hopefully in the next couple of months, Mr. Terrence Hinton. I don't believe he's here today, but hopefully by the time we get together, I think the goal is May.
That's when that'll be his first meeting.
Yes.
He's doing his training right now.
Yep, so the goal is to have him in a seat by May, which is exciting. That still does leave us with some vacancies. So my encouragement to folks who are watching, and to those of you who are already on the board, or folks who are listening and maybe know someone that you think would be a good addition, seats are still open, so we would strongly encourage you to apply and to join us. Also, I will note that it is coming up on election season for us. So next month at our March meeting, if folks could have either nominations or motions to nominate prepared, or at least noted, so that by April we can have elections for, it's just chair and vice chair. All right. All right, so moving on to reviewing cases, I will turn it over to Board Member Nathan.
Okay, thank you. This is case number 2023-0205 and 0208. The case concerned an officer-involved shooting. The complainant was in the general area but not involved in the incident. The complainant alleged that the officer's behavior was reckless, unnecessary, and senseless. Complainant witnessed the shooting, dropped to the ground to avoid any gunfire, and injured her knee and left side as a result of dropping to the ground. The shooting took place in response to a report about a known drug dealer who was driving a 2002 Dodge truck bearing a particular license plate. The truck was stopped. The driver fled, was observed reaching for a gun in his waistband. The officers were chasing him on foot. When they saw him reaching for the handgun, the officers shot him. Two officers' statements were consistent with body-worn camera evidence. On the body-worn camera, when the officer asked, "Where is the gun?" the suspect yelled, "I threw it." The Firearm Review Board found the officers' actions were supported by CPD policies. The DIG agreed. We agreed with the DIG, and so the recommendation was closed with a finding of administrative closure. That's okay. This is case number 2024-1042. This case involved 3 allegations that resulted from an officer's pat-down of the complainant, who the officer believed might be involved in a drug deal, but was in fact just stopping with his coworker for lunch. The Columbus DIG's investigation consisted of a review of body-worn camera evidence, review of the cruiser video system, review of applicable CPD policies, physical assessment of the incident location, a telephone interview. And so, excuse me. sorry. There were 3 allegations that the officer wrongly detained the complainant for an investigative stop. The Columbus DIG found that the officer briefly detained the complainant due to a reasonable suspicion to believe that criminal activity was afoot. The complainant was monitored via a crime camera in the neighborhood and suspected of open-air dealing due to the activity in the area that was known for illicit narcotics activity. The investigation found that the officer's detainment was supported by CPD policies, was recommended that the allegation be closed with a finding of unfounded. Second, he alleged that there was an unlawful search, and the review of body-worn camera indicated that the officer conducted the search within CPD policy, so DIG recommended that this allegation be closed with a finding of unfounded. And finally, the complainant alleged that the officer was rude to him. The review of body-worn camera didn't indicate that the officer was rude, and so it was further recommended that the allegation be closed with a finding of unfounded. However, the DIG added an allegation, and that is that the officer failed to advise the channel dispatcher of the location and nature of the run as it related to self-initiated activity. As a result, the police-citizen contact that occurred wasn't recorded on the electronic record in the CAD database, and this should have been reported as a 1049A narcotics complaint. The failure to advise was not within CPD policy, and so it was recommended that the allegation be closed with a finding of sustained. And so that's case 1042. Case number 1349, the incident that gave rise to the complaint concerned a fight involving a large number of teens at the Linden Recreation Center. At least one girl was stabbed, another maced. The girls ran from the scene, showed up at the complainant's house, which was a few blocks away. The complainant didn't know the girls, but let them in. She believed they were being chased. She called 911. The police arrived, entered the home, searched the premises. The complainant alleged that the officers were involved in an improper, that they were improper in their response to the stabbing incident by searching the premises. In this case, the officers were trying to secure the premises and to make sure that there wasn't an assailant on the premises or possible suspects or additional victims. And so with respect to both officers, the DIG conclusion was a finding of unfounded regarding the complainant's allegations. So that's case number 1349. Case number 1373. The incident arose as a result of officers being told by a helicopter, the officers in a helicopter, that a car they were pursuing had pulled in back of a building. Someone was getting out of the car. The officers on the ground confronted the person in back of the building. The complainant, who was the one arrested by the officers, complained that the handcuffs that were put on him were too tight and that the CPD officer wouldn't loosen them. He complained second that the CPD officer snatched him from the car for complaining that the handcuffs were too tight, that the officers jumped on him when he was face down and started taking the jewelry off his hands and hobble strapped him because a CPD officer said he was trying to run, and the officers didn't give their name or badge number. In this particular case, the basic finding was that the complainant began to smack his head against the inside of the cruiser and said that he was going to kill himself. As a result of that, the officers hobble-strapped him. The complainant never told the officers that the handcuffs were too tight. So with respect to that allegation, it was closed with a finding of unfounded. Because he was smacking his head against the inside of the vehicle and declaring that he was going to commit suicide, he needed to be pulled from the vehicle. As a result of that, there was no evidence to substantiate the complainant's allegation that he was wrongfully pulled from the vehicle. It was recommended that the allegation be closed as unfounded. Third, the complainant, as I said before, was hobble-strapped, but that was to protect him from the threat of killing himself. And finally, there's no evidence that the officers refused to give their name or badge number. So with respect to that allegation, it was closed as unfounded. That's case 1373. This is case 1442. In this case, this was a complaint alleging that the officer advised the complainant that he had to identify himself or he could be arrested, although he was just a passenger in the vehicle. And second, that the officers were not truthful about the complainant not wearing a seatbelt. And third, they did not allow the complainant to get items out of the vehicle before it was towed. And so this complainant was a passenger in a vehicle that was stopped. In this case, let's see here. It was within CPD policy for the officer to ask the complainant to identify himself when he made the traffic stop, because according to CPD policy, the driver and the passengers are required to identify themselves. So regarding that allegation, DIG closed it with a finding of exonerated. Second, the investigation revealed that the officer stated he didn't observe the complainant without a seatbelt, and yet the officer claimed that the complainant was not wearing a seatbelt. The officer lacked firsthand knowledge, and the officer was adamant that he wasn't wearing a seatbelt, even though he already admitted that he didn't see anything. So with respect to that allegation, it was recommended that the allegation be closed as sustained. And finally, according to CPD policy, the complainant did not have the right to take his items out of the vehicle prior to it being towed. Therefore, it was recommended that that allegation be closed as exonerated. That's case number 1442. Regarding case 1456, the incident arose as a result of a jaywalking violation by the complainant, which the police observed. When the police, via verbal commands and their siren, attempted to stop the complainant's son, he quickly climbed the stairs of his home and attempted to enter the door of the house. An officer chased him, tackled him, and they crashed through the front door of the house. The officer then dragged the complainant's son down the concrete stairs. There are two allegations. One was excessive use of force, And second, that the complainant's son was placed in a police car for no reason. Regarding allegation 1, the DIG sustained the finding of excessive use of force in dragging the complainant's son down the stairs for a minor misdemeanor. Concerning the complainant's son being placed in the police officer's car for no reason, the investigation found that they did have probable cause for a stop. They did issue commands for the complainant to stop, and because he failed to comply, he could be placed in the police car. So with respect to that allegation, there was a finding of unfounded in case 1456. Case 1474. This incident arose as a result of police responding to a burglary call in which the complainant alleged that items had been taken from his storage locker. The officer ran a warrant check on the complainant, which the complainant alleges was misconduct. The complainant also alleges that the officer threatened to arrest him for calling 911. The warrant check was within CPD policy, and so with respect to that allegation, the police were exonerated, and the evidence found no evidence that the officer threatened to arrest the complainant, and so with respect to that second allegation, there was a finding of unfounded, and that's case 1474. Case 1489. This complaint arose as a result of a domestic violence incident involving neighbors of the complainant. The suspect of this domestic violence incident was a friend of the complainant, came into her apartment to calm down when the police arrived. The complaint alleges, number one, that the officer attempted to enter her residence without knocking or asking for permission, and two, that the officer was rude and disrespectful by advising that he could do whatever he wanted, and three, that the officer was rude when her husband asked for his badge number, and he responded, "Do you want to write it down or just take a picture since you want to complain?" The DIG found that the officer's attempt to enter the residence without knocking, or that the allegation that he attempted to enter the residence without knocking was unfounded. In fact, the DIG officer did knock before the suspect exited the apartment. Body-worn camera evidence is consistent with that statement. The officer asked for the suspect to come out. The suspect did. There was no evidence that substantiated the complainant's allegation, so the allegations were closed as unfounded. Second, regarding the officer being rude and disrespectful by saying that he could do whatever he wanted, in fact, there was no evidence that the officer ever said that, and so with respect to that allegation, there was also a finding of unfounded. And third, there was no evidence that the officer was rude or discourteous, so with respect to that allegation, the DIG further found that the allegation be closed as unfounded. That's case number 1489. Case 1497. The complaint arose as a result of a police stop of the complainant's son, and his associate because of an illegal drug possession by the complainant's son and multiple warrants concerning him. 3 allegations were made by the complainant. First of all, that the complainant alleged that she urinated on herself because she informed the officer she was diabetic, she couldn't hold it. The investigation found there were other factors that elongated the detention that were outside the officer's control, such as the complainant's son's initial refusal to hand over the drugs, the officer's actions of the brief detainment were within CPD policy, so DIG recommended with respect to this allegation, there be a finding of exoneration. Second, the complainant alleged that the officer was rude and discourteous. Body-worn camera was reviewed. There was no evidence that the officer was rude and discourteous, so the DIG recommended allegation number 2 be closed as unfounded. And third, the complainant alleged that the officer improperly searched a vehicle when it was impounded for window tint. The investigation found that the officers did conduct a search of the vehicle, but the search was within policy. The officers conducted a search of the motor vehicle in relation to the arrest of the complainant's son, who was arrested with suspected cocaine in his possession when he came in contact with CPD. So the officers did not conduct a search of the vehicle until they had probable cause, and so allegation 3 was closed with a finding of unfounded. Case 1572. I have 3 more. Case 1572. The incident arose as a result of a traffic stop in which the police found a white powdery substance inside the complainant's car. The complainant claimed that this was cleaning supplies, which he spreads around the vehicle because he likes the smell. The complainant alleged officers' misconduct for treating him unfairly and in detaining him while they collected some of the substance that was on the carpet and around the car that they believe might be illegal narcotics. And so in this case, the officers conducted an investigation, recovered the substance, and submitted this substance for analysis. There's no evidence to suggest that the complainant was treated unfairly during the stop. The officers' actions were supported by CPD policy and procedure, and so the Columbus DIG recommended that the complaint be closed with a finding of unfounded. Yeah, please.
Do we have details about the nature of the initial stop?
Yeah, in this case, let's see here. I'm trying to see what the basis was for the initial stop. I was focused on this material that was all around the car.
He said that he was stopped for traffic violations.
Yeah, he was pulled over, and the complainant confirmed that the officers used lights and sirens to initiate the stop. He was told he was stopped for traffic violations. No, that was it, just
the traffic violations.
traffic, but yeah, there's nothing in the report. I don't know if DIG has any further information about the nature of the traffic stop. It just said traffic violations in the summary.
I don't have any additional information. I can get that if that's what you want.
It's actually in here. It said he committed a failure to signal and a stop sign violation.
Yep,
That's on page 3.
Oh, yeah,
thank you.
Yeah, that's helpful. I was just
failure
wondering.
to signal, yeah.
Yeah, I was just wondering, it's, as we see a lot of these cases where it comes up and there's a traffic, that's the traffic violation. So just trying to get a sense of process versus whether or not there was any sort of pretextual pieces around this, or just so that we can get a sense of these patterns, because there's a number of these traffic violations, and then they happen to then be searching for, potential narcotics. It's a pattern we see. I don't know if that's just a practice or if it just happened to be that he was being pulled over for a traffic violation. Yeah, that was a general question, yeah. I don't know if we've looked at that or if any of my colleagues, if you've noticed that or seen that a few times throughout some of our cases. There's a number, comes up with a traffic violation and then then this process happens versus whether or not, and the reason I bring that up is because it mentioned there was no evidence that they were treated unfairly because of a traffic stop, but there isn't a whole lot of detail behind the actual alleged traffic violations itself. And so I don't know if this is somebody that they've known, or a vehicle that they've known or have seen around, but that's been something that has come up several times throughout our cases.
I don't know how they would be able to, I mean, DIG, do you have any response? Like, how would you even begin to determine the legitimacy of the traffic stop? You would probably look at any kind of vehicle evidence for whether there's video or something that there was a failure to use a turn signal or something like that, or?
What I will say, and I'll definitely let my attorney kind of fill in, is that any complaint that we get that involves a traffic violation, we do look at the body cam, and if there is footage from the vehicle, the police vehicle, we look at that to see if the traffic stop fell within the guidelines of when an officer is able to do that. If not, then obviously anything that occurs after that would be a violation of CPD policy. But if the traffic stop on its face, the officer is able to conduct a traffic stop, and we're able to see that the traffic stop is, in fact, there's no policy there, then anything that follows, whatever actions the officer takes, that's not something that would be a violation of CPD policy. But I'll definitely let my attorney say if you have anything additional you want to add.
I think, you have your regular cookie cutter traffic stop, right? Where there's a traffic violation and the officer is pulling someone over for violation of the traffic stop. Traffic stops are used as a tool by CPD, right, to stop individuals and further an investigation of an individual who they believe is committing other crimes. It doesn't mean that the officer can just stop that individual without a reason, right, without reasonable suspicion. But you might see a situation where there is an ongoing investigation of an individual. That individual makes a traffic violation, and then the officer stops him for that traffic violation and is able to further the investigation for whatever they have that may or may not be related exactly to that stop. Again, while they have the person stopped, they have to have reasonable suspicion for the stop. And if they engage in additional activity in a search and a seizure, they still have to have the lawful probable cause to be able to do that as well. So there are instances where you will see pretextual stops being used to further an investigation that CPD has. It still means that CPD has to follow the law and that a person's constitutional rights need to be followed during that process. Most of the time, you could see in a police report if an officer says this is a known person, right? They still have to have the underlying reasonable suspicion to make the stop.
It's great. Thank you for that.
And if I could add, and then sometimes, if they want to make that stop, they'll follow that car for a little while, and if she doesn't use the turn signal, or if there isn't a light on the license plate, or things that normally one isn't stopped for, but then the officer will use that as that tool.
Yeah.
Yeah.
Thank you.
Yeah.
Helpful.
Okay. This is case 1581. The incident arose as a result of the officers being dispatched in response to a call involving a woman alleged to have a knife. Complainant fit the description given by the dispatcher, and was also named in the call. That is, the complainant was named. When the officers arrived, the complainant told them she didn't have a knife. She brought 3 allegations against the officers. First, that the officers wouldn't listen to her side of the story, and there was no evidence that substantiated the complainant's allegation. The officer alleged that he did listen to his side of the story, so with respect to that allegation, it was closed as unfounded. Second, that the complainant alleged the officer was rude and intimidating. A review of the body-worn camera revealed that neither of the officers were rude and intimidating. So with respect to the second allegation, it was recommended that the allegation be closed as unfounded. And third, that the officers took a report and had the complainant listed as a suspect, which she didn't believe was correct. The initial call was for service of a person with a knife that fit the description of the complainant. They were dispatched to the call, assessed the situation, completed their report. They did list the complainant as the suspect, and in so doing followed CPD policies and procedures. It's recommended with respect to that allegation that it be closed as exonerated. Finally, yes. The incident, case number 1590, the incident arose as a result of officers being dispatched in response to a complaint of a man with a knife. The complainant in this case was the then girlfriend of, let's see, the complainant's then girlfriend, that's it, told the officers that she and the complainant had been fighting for several days, that he threatened her by threatening to punch her in the face and to kill her. He also wanted to engage in a knife duel. The officers then went to the apartment, engaged the complainant. The complainant alleged that the officers did not tell him what he was being arrested for, that they never read him his Miranda rights, and the officers took his apartment key out of his wallet without his permission and provided the key to his now ex-girlfriend, who at the time of the incident was his girlfriend. In this case, there were, so there's 3 allegations regarding the first allegation, that the complainant alleged that the officers didn't tell him what he was being arrested for. The officers did advise the complainant that he was being charged with aggravated menacing and domestic violence. And so in this case, it was recommended the allegation be closed as unfounded. Second, that the officers never read him his Miranda rights. The body-worn camera indicates that the officer did read the complainant his Miranda rights, and so it was recommended that this allegation be closed with a finding of unfounded. And third, that the complainant alleged that the officers took his apartment key out of his wallet without his permission, and provided it to his now ex-girlfriend. The complainant gave the officer permission to take the key out of his wallet and give it to his now ex-girlfriend, who at the time of the incident was his girlfriend, and so it was recommended with respect to this allegation that it be closed as unfounded. So our subcommittee agreed with all of the DIG's findings, and then there's an additional motion that I need to make with respect to the additional the addition by DIG, the DIG in case number 1042. So I move to accept the DIG's findings with respect to case 205, case 1042, case 1349, case 1373, case 1442, case 1456, case 1474, case 1489, case 1497, case 1572, case 1581, and case 1590.
Thank you for the second. Anyone have any other questions for the subcommittee or discussion?
I had a question of the DIG. We wrote regarding the search of the premises in the case where the girls came into the house. That was case number, let's see, 1349, I think. Is that it? No. Let's see here. Yes, that's the one. Where a girl was stabbed, she came into, they ran into the neighbor's home. A search was conducted. I was still, you refer to Attorney Furby's handbook, I think, in this case, a comprehensive guide to home entries. Is there something in that handbook regarding the length of time? I'm just curious, the length of time that an officer can go about conducting a search in another part of the house or in the basement, what could be open or not, or is it just a sort of general look around to see if there's anyone in the house or hiding in a closet to make sure that the premises are secure, that is, that there's no assailant there, there's no other victim there. So in other words, I'm not able to open a drawer because I know that the assailant is not hiding in a drawer, or there's no potential victim. I can't go into, spaces in which they could not fit. I mean, is there like there's this rule of reasonableness that a search like this is just a general look around? I just was curious when I read the case, because she alleged that he was gone for a very long time in the basement. I'm just wondering, like, how one assesses these things.
You take a stab. So as far as a section in the handbook, the city attorney updates will generally be very specific to a specific issue, not necessarily comprehensive. However, as a specific search, right, and the length of time and what an officer can do while searching is largely dictated by the language in the search warrant, unless there are other, like,
I don't think there was a search
exigent
warrant. This was an exigent
circumstances.
circumstance.
Okay, so if it's an exigent circumstance.
Yeah, he was looking
you-
for
you-
potential assailants or victims that may have
Then the-
resulted from this stabbing incident.
then the search would be what is reasonable to be able to make that determination. And so you'd have to look at the facts of the case. It's always going to be case specific. I
Yeah,
hate to say it
that's what I'm saying.
depends, but it depends largely, unless you have a specific warrant that has specific language, right? If you have an arrest warrant, you're looking for a specific person. If you have a search warrant and you're looking for a specific thing, if it is exigent circumstances, you're largely able to check things that make sense as to why you're in there. You just have to be able to articulate what that is, and the facts have to be able to support that.
Circumstances, the officer's unfamiliarity with the layout of the home, how big the home is, whether anybody's obstructing them while they're trying to search through the home, all those types of factors. Would they need to be able to articulate all of that?
Okay.
Drawer.
I feel pretty comfortable saying drugs in a drawer would not be allowed. I mean, I don't want to go too far afield here, but, depending on the nature of the stabbing and what was alleged, if something was severed, and they're looking in a place where they would be looking for something like that, but again, fact specific.
Yeah. Well, in this case, the stabbing didn't happen on the premises. They happened in a schoolyard or park, and then they ran to the home, and I just, yeah. So we have a motion on the floor regarding, I'm sorry?
Sorry, real quick. So did you get the answer to what you're?
Well, it's
trying to get us?
totality of the search. There's no evidence. I don't have any evidence in this. All we have is an allegation by the complainant that he was gone, in the basement for a really long time. She thought that was, a violation of her rights without a warrant, that, he alleged that he was looking for a potential assailant or victim in the basement. I just was trying to get some sort of measure of like what, so, yeah, I don't have a,
And what was that analysis from there, just about that?
the DIG found that it was within policy, that there was, I mean, I don't think we have I don't know if you did like some sort of time study on the body worn camera, you know, whether that was done or not.
I just pulled up the report. The allegation was that the officers improperly searched her residence. And so what we found is that the reason that the officers were searching the residence is because they responded to a stabbing incident, and that was one of the reasons when they got there, I think I gave you the policy that talks about when they responded, why they actually searched the residence. It wasn't a time restraint. It's just that the complainant felt that the officer should have not searched the home at all.
Or gone in the basement.
Well, I mean, that,
No, I think
I know
that's
what you're
what was in the.
saying. Yeah.
Yeah.
but the officers, when they respond to an incident, whether they are doing exigent circumstances or they're searching the premises to make sure that everything is safe, and the fact that they responded to somebody that I believe, I'm trying to read that, I believe the information that they got was that the person was stabbed, and then they received information
Yes.
involving the teens, and then they received information that the teens responded to a location, and that's why they responded. So the stabbing, I believe, happened at another incident. The officers responding and doing a search would most likely make sure that there were no other suspects
Yes.
in the house, so, I mean,
Yeah, that's fair. I do think the question I would have, though, is this question about the basement or the extent of the search, right? You were talking about exigent circumstances and totality of the circumstances. I don't know, but based on the investigation here, there was nothing out of the ordinary. It seemed within policy and within the bounds of the law. Is
no,
that-
and we also provided, and I can always, I think when we usually send the questions out back to the committee, I don't know if we've been sending it out. Stephanie, can you tell me, have we been sending it out to everyone, or do we just send it back out to the committee that asked the question?
I get a legal advisory that tells me to send it to the board, I'll send it to the board. That legal advisory went just to that committee, but Brooke just asked me, the board just got it.
Okay,
I
thanks.
just sent it out to the board.
And we can make sure, I think we tried to make sure, and that could be on my part, that I'll just try to make sure, whenever we get questions, that not only do we answer the committee, but we can try to make sure that we send it out to all the board members. So again, so if that question comes up and the board has a discussion, other board members can say, oh yeah, I did get that question from the committee and the documents, because we do try to make sure that, we just want to make sure that we're clear in providing any feedback. So I'll just say from now on, Stephanie, I know sometimes we just respond, but let's just make sure we send it out to everybody. Thanks.
Thank you.
And then there was a second, do we need to vote on the first motion first?
Just to keep it clean, probably.
Yes.
Okay. If no other questions on the original litany of cases, all in favor, please raise your hands. Okay. Any opposed? Abstentions? All right, motion carries. All right, you can have the extra space for the extra motion now.
And then
From
there
Yeah,
was
Member
an
Strickland?
abstention.
Oh, there was an extension. Okay. On which one? All of them?
I mean, I guess because that was the motion, but yeah, that's fine.
Well, you can make it specific to
For
the case.
the cases that I was not here for when I saw the readout, so.
Gotcha. Let's see. Do you remember which one you came in for? Is it 1497?
I can just do them all. I'll abstain from them all. That's okay.
Okay.
Don't think-
Do you have that, Stephanie? All right, thank you. All right, go ahead, Board Member Nathan.
And then in case number, I think it's case number 1042, the DIG added its own finding, and that, let's see. to find that.
That he didn't record.
They failed to notify they failed to advise the channel dispatcher of the location and nature of the run. It was self-initiated activity, and there wasn't an electronic record of their activity. That was a violation of CPD policy, and so it was recommended that be closed with a finding of sustained in case 1042, and so I move to accept the DIG's finding with respect to that.
May I have a second? Thank you. All in favor, please raise your hands. Any abstentions? Board Member Strickland? All right, motions carry. Now on to combined committees 2 and 3.
Case number 2024-1322. This was a complaint against 2 Columbus CPD officers. The complaint alleged that the officers did not properly investigate a domestic violence incident. The DIG's investigation consisted of CAD materials, BWC, a review of the police report, and all applicable policies. They also interviewed the officers involved. With regard to the allegation that the officers did not investigate the DV incident, the investigation found that the police response and the handling of the incident were within CPD policy and procedure, and the recommendation was that it be unfounded. The allegation of DV was against the son of the complainant. The officers saw no signs of violence. Per the BWC, there was no sign of violence involving the mother, son, or live-in girlfriend. The BWC showed the officers making suggestions for possible solutions. There was no probable cause to arrest. Our subcommittee reviewed it, and we agree with the findings of the Inspector General. Case number 2024-1388. This was an allegation of misconduct. The complainant alleged that the CPD officers, 1, searched her home without a warrant, were rude to her by asking her if she can't read when asked for their names and badge numbers, and number 3, slammed her to the ground. The investigation consisted of review of CAD data, review of BWC, review of IAB use of force report, and also review of photos that were sent by the complainant, and review of policies. With regard to allegation number 1, the investigation found that CPD officers did not violate policy when they searched the home, as the officers conducted a protective sweep of the home, given the nature of the call. This was a call for the individual's son was threatening suicide. And given the nature of the call and the facts provided to them, which constituted exigent circumstances, therefore the the DIG recommends a finding of unfounded as to allegation number 1. With regard to allegation number 2, the officers did not violate policy as to being rude. When they were asked for their names, they gave their names and they gave their badge numbers. And they never asked her if she couldn't read. Therefore, this allegation was closed as unfounded. With regard to allegation number 3, the investigation revealed that the officers did slam her to the ground, as alleged. Based on the review of the BWC footage, the DIG did not observe the complainant appearing to have thrown herself to the ground as written in the use of force report. Sworn personnel shall not use more force than reasonable in an incident. Given the availability of other officers in the immediate vicinity for assistance, less force may have been used to safely obtain the desired effect of moving the complainant to the living room, as written in the use of force report. The DIG recommends that this third finding be sustained. The third allegation was that the officer slammed her to the ground, and the DIG found that this allegation be closed as sustained, as the officer did slam her to the ground. our subcommittee reviewed this, and Crystal Jackson and myself did go and review the body cam because it was hard to see from the written case on this particular one. And upon viewing the body-worn camera, we did exactly see what the DIG was saying when they indicated that she was slammed to the ground. The use of force, you could see that the use of force was more than was necessary. It wasn't just basically a moving of the individual over. It was a movement that pretty much slammed her to the ground that was not necessary. And the officers in this particular case kind of lost control of the scene. They didn't direct where everyone should go, and it wasn't all their fault, actually. There were no directions or anything given, but the complainant who did call wanted them to have wanted a warrant when she in fact had called because her son, because they needed help. Her son was attempting suicide, and they needed to search to see if there were other weapons in the basement or if someone else was going to hurt themselves. So it was a very volatile situation, and the officers did the best that they could, and then she inserted herself in the hallway and wouldn't allow the officers to go downstairs, but there was more force than was necessary. So upon review of the body-worn camera and upon discussion by our committee, we did agree with all three allegations that as per the Department of the Inspector General.
So I'm just trying to get a sense of what was in the summary, and then also what was maybe your opinions or analysis, because you mentioned it wasn't all their fault. It was that wasn't actually written anywhere, or was it?
No, that was our subcommittee discussing it and then coming to that. It was, I don't know what to say, Kyle. It was us reviewing it and coming to, it was our subcommittee reviewing it and then me saying that I'm not totally blaming the officers for what was going on because there was a lot of chaos in the house. Now, you want me to explain what I mean by that?
Well, it's just kind of hard to, at least personally, it was hard to understand what was written. Was
Do you want me to read the
summary
case?
from the Department of
I'll
Inspector
go ahead and
General,
read it to you.
and then what was inserted from your opinion. So I was just trying to get a sense of what.
Would you like for me to read the facts and the BWC, and would that help? Would that be helpful to you?
Not right now. I mean, you gave an overview. I was just trying to get clarification on what was indeed written from the Inspector General and what was your opinion.
Okay, then I'll read to you what was written by the Inspector General. Would that be good?
I mean, I think I've got the summary now, thanks to your clarification. That was helpful.
Okay. So I'm not clear what you would like from me. What would you?
At least personally, it's helpful, typically, we'll read the summary of the case so that these are the words of the Department of Inspector General.
Okay.
Their report, an impartial review of the process, and then if you want to add in your additional opinions or the discussion you had with your subcommittee, just some additional clarification would be helpful, because when you say it wasn't entirely their fault, it was also this other person's fault, I think it's important to be clear that that is your opinion and not through an investigation or analysis that was done by the investigators.
I thought that was clear, but maybe if it wasn't totally clear, that was not written in the report, because I finished the report and then I clarified it, and then I spoke on behalf of myself.
Okay.
So the next time, when I read my next case, I will say that for you.
Yeah, I
if
think
you
that's helpful,
wish.
because I mean, I think that the statements you're making are it's a subjective statement that you're making. And it's not necessarily informed by a full review of the situation.
Sure. And you might follow with me, so you'll realize when I'm ending also, as you're doing. All right. So, are you finished, or do you need anything else?
No, I was, again, please go on.
All right, thank you. Case number 2024-1419. This was an allegation of misconduct. The officer in this situation, the complainant alleged that the officer banged on her door and did not announce himself, and number two, tried to get into her locked residence. The DIG's investigation consisted of CAD data, BWC, and a review of policies. Regarding allegation number one, the investigation found that the CPD officer announced himself, knocked several more times, and however, the policy governing arrests and warrants does not specify that a patrol officer must announce themselves when knocking. There is no evidence to support the complainant's allegation. Therefore, there is a recommendation that this be closed as unfounded. Regarding allegation number two, the CPD officer did push down on the handle of the door, and the door slightly flexed away from the frame without opening. However, there is no CPD policy that prohibits an officer from checking to see if a door is secured. The officer was checking to make sure that the door was secured before he left the area. The officer's actions did not violate any CPD policy. Therefore, it is recommended that the allegation be closed with a finding of unfounded. Our committee reviewed the case. We agree with the Department of the Inspector General. That last sentence was subjective. As to the next case, 2024-1441, this is an allegation of police misconduct. The officers responded to the complainant's neighborhood and arrested a suspect who was fleeing from the officers while riding a bicycle. The complainant, one, alleged that the suspect was arrested, the suspect was arrested. A Columbus police officer drove a police vehicle through his front lawn, causing unnecessary damage when he could have driven away from the scene by way of the alley. The DIG's investigation consisted of an interview with the complainant, interviews with the responding officer and lieutenant, review of CAD chronological data, review of BWC, also review of secure video footage obtained from the complainant, and a review of policies and procedures. With regard to the allegation, the investigation found that the officer was unable to drive backwards down the alley towards Steele Avenue or drive forward on Westmore Avenue due to the large amount of police vehicles, medical vehicles that had responded to the scene. The investigation found evidence that the alleged incident happened. However, the officer's actions are supported by policy and procedure. The IG's recommendation is that the allegation be closed as exonerated for this officer. The investigation, however, found that the lieutenant used profanity during the apprehension of this suspect. So that was against policy and procedure. So there is a recommendation by the IG that this be closed as sustained as to the lieutenant. The committee agrees as to both the finding of the IG as to the lieutenant and as to the officer. When our committee reviewed this, we found that this is our committee's, this is not written by the Inspector General, but this is our committee's personal finding, subjective finding. The investigator here was very thorough. They went out to the scene, and we just wanted to commend the investigation that was done here. They went out to the scene on this case, watched the BW, just went way above and beyond, did a wonderful job, and the write-up was really very good. As to case number 2024-1449, in this particular case, this was an allegation of misconduct. The complainant alleged, one, the CPD officer broke into her home in uniform while he was on duty. Number two, the officers ripped a flag from the wall and bent a sign while attempting to remove it from the wall. And number three, an officer threatened her through communication with her father. The investigation consisted of the interview of the complainant, interview of the complainant's father, interview of the focus officers, a review of the ring camera footage, and a review of policies and procedures. With regards to allegation number one, the CPD Internal Affairs Bureau conducted an investigation, first of all, and determined that there was no criminality involved. Based on the lease agreement between the complainant and the officer, and the statement of both the complainant and her husband that the property had been vacated, CPD IAB found no criminality. The Columbus DIG found no evidence that substantiated the complainant's allegation in the subsequent administrative investigation. The property owner in this case, who is also an officer, was off duty at the time of the incident. The second officer, an on-duty uniformed officer, was called to the property at the recommendation of the property owner's attorney to stand by as an officer, as a uniform officer presence when entering the property. Based upon the investigation, the IG recommended that this allegation be closed as unfounded. With regard to allegation number two, the CPD IAB conducted an investigation and also determined no criminality. There was no evidence that the officers damaged the complainant's property. This was number two allegation, that they ripped a flag from the wall, and there was no evidence of that. The DIG found no evidence that substantiated the complainant's allegation in the subsequent administrative investigation. Therefore, it is recommended that this allegation be closed as unfounded. As to allegation number three, the investigation found while the officer had a conversation with the complainant's father, the officer was advising him of the potential outcome of the continued litigation, not making a threat. Furthermore, the complainant's father did not regard this conversation as a threat, and the officer stated she did not intend it as a threat. The IG investigated and found no evidence that substantiated this allegation. Therefore, they recommend that this be closed as unfounded. We, as a committee, reviewed it, and we concur with the findings of the Inspector General. 2024-1466. This was, let's see. This was a misconduct allegation. And in this, CPD called, the complainant called CPD to respond to a male yelling, cursing, and making threats from the parking lot of her apartment complex. The complainant alleged, one, the officer did not make the man leave, even though he was threatening to shoot people. Number two, the officer looked into her vehicle and ran her tags without probable cause. And three, the officer threatened to tow her vehicle due to her vehicle being parked in a handicapped spot. The DIG's investigation consisted of interviews of the officer, CAD and BWC footage, and policy and procedure review. During the course of this investigation, the DIG discovered another possible policy violation as the officer was observed making rude remarks. Rude remarks and used profanity directed toward the complainant during their interaction. In regards to allegation number one, the investigation revealed the alleged incident occurred and the officer's actions were within CPD policy. The officer advised the complainant that since the tenant, the suspect was visiting, was not asking that the officers trespass the suspect, they could not take any action. Therefore, it is recommended that this allegation be closed as exonerated. With regards to allegation number 2, the investigation revealed that the alleged incident occurred and that the officer's actions were within CPD policy. The officer searched for a handicapped placard that would be in plain view by flashing his light through the windows of the complainant's vehicle. This was a self-initiated enforcement action which would allow the officer to run the complainant's vehicle information. Therefore, it is recommended that this allegation be closed as exonerated. With regards to allegation number 3, the investigation revealed the alleged incident occurred and the officer's actions were within policy. The officer addressed the absence of a handicapped placard with the complainant, and she confirmed she does not have the handicap placard. She stated she was parked in the spot based on verbal permission from the apartment complex. The officer advised her that this was not sufficient to allow her to park in a handicapped spot and could result in her vehicle being towed. Ultimately, her vehicle was not towed. Therefore, it is recommended that this allegation be closed also as exonerated. In regards to the DIG allegation, a review of the footage revealed that the officer made rude remarks and used profanity directed toward the complainant during this interaction. Therefore, it is recommended that this allegation be closed as sustained. Our review committee agrees with the DIG finding as to both the 3 allegations, the 3 original allegations, and the profanity allegation, profanity-rudeness allegation initiated by the Department of the Inspector General. 2024-1487, this is a misconduct allegation. Complainant alleged that CPD was not cooperative with her by laughing when she asked how to spell his name. 2, the officer continued to speak with her minor daughter after being asked not to. Number 3, the officer told the complainant and her daughter how to handle her daughter's disability. And 4, the officer did not assist her daughter while in crisis. Instead, he continued to agitate her deliberately. The investigation consisted of CAD data, review of CODA bus footage, and a review of an interview with CPD officer, and a review of policies. With regards to allegations 1, 2, and 4, the DIG found no evidence to substantiate the allegation of misconduct. The officer gave his name and spelling. He was calm and respectful throughout this interaction with the complainant's daughter. There was no evidence that corroborated the allegation that the officer told the complainant or her daughter how to handle her disability. Therefore, all of these 3 allegations are unfounded. As to allegation number 2, the DIG found existence that substantiated her allegation that the CPD officer continued to speak with the minor child after the complainant asked him not to. However, the CPD officer was responding to a disturbance on a bus, which is a 3rd-degree misdemeanor, and was investigating the incident. The officer was within policy to speak with the minor daughter involved in the incident and causing the disturbance. Therefore, it is recommended that this allegation be closed as exonerated. We, as a committee, agree with the findings of the Inspector General. 2024-1528. This was a misconduct allegation. This was the IG received via email, misconduct from Internal Affairs. The complainant alleged that a CPD officer had stuck a finger in his rectum while taking him into custody. Upon interview, the complainant withdrew his allegation. The DIG's investigation consisted of an interview with the complainant, a review of CAD material, and a review of body-worn camera. So this allegation came from Internal Affairs, so they had already conducted an investigation. In regards to allegation 1, the investigation found no evidence that substantiated the complainant's allegation. Additionally, when Columbus DIG attempted to conduct an interview with this complainant, he requested this be withdrawn. Therefore, it is recommended that this allegation be withdrawn. This is, our review committee reviewed it, and we concur with the findings of the Department of the Inspector General. Also, now this is subjective. I would think that you would know that this is subjective because I've finished my summary. Also, the BWC was reviewed by the Inspector General, and 2 sergeants and 1 officer were present at the arrest. So even though the individual withdrew it, since this is such a serious allegation, the Inspector General did review the BWC, and there were 2 sergeants, 1 officer present at the arrest of the complainant. And through the BWC, you could see that the sergeant's hand rested on the complainant's posterior approximately for less than 4 seconds. You could see all of his fingers and thumb visible. So this was a thorough investigation by the Inspector General, per our review committee. As next case is 2024-1546. This was an allegation of, I think it's misconduct, alleging the, number 1, the officer did not complete a report to accurately reflect what took place, and the officer, and number 2, the officer refused to attempt to make contact with the suspect. The DIG investigated this, and they used CAD, BWC, interview with the officer, review of policies. With regards to allegation 1 and 2, the DIG found no evidence to substantiate the complainant's alleged allegation of misconduct. Review of the BWC and police report confirmed the officer completed his report based on the information that was given to him. He offered to stand by the complainant's home until she left. He advised her of her rights to prosecute and where to go, and he accepted a phone call from the complainant's phone while he was there and attempted to speak with the suspect. Therefore, it is recommended that both of the allegations be closed as unfounded. We reviewed this case, and our review committee concurs with the Inspector General. 2024-1595, this was also an allegation of misconduct. The complaints originated from an interaction between between the complainant and CPD officer during a 1016 disturbance call. The complainant alleged that the officer gave her false information and told her the insurance information was in a report, but it was not. The DIG's investigation consisted of an interview with the complainant, CAD, BWC, review of CPD incident report, review of Premier 1 case file, review of CPD policy and procedure. With regards to allegation number 1, the investigation revealed that the allegation occurred, but the officer acted in accordance with CPD policy. On November 7, 2024, the complainant's family dog was run over by an unknown driver. The complainant revealed to the Columbus DIG in her interview that it was important for her to have the other person's car insurance information because the complainant has no property, home, pet insurance. She needed the suspect's car insurance information to file a claim and pursue reparations for the death of her family dog. The complainant requested that the officer obtain the insurance information from the other involved party, but there is no policy that indicates the officer is required to obtain or provide that information for this type of run. So that's important to keep in mind. There is no policy that indicates the officer do this. A review of the incident report, Axon evidence, and Premier 1 case file revealed that the insurance information was never uploaded by the officer. The officer responded to a disturbance call. For this type of run, the officer acted in accordance with policy and procedure. Obtaining and providing insurance information is not required by policy for this type of run. Therefore, it is recommended that this allegation be closed as exonerated. So our committee reviewed this, and we concur with the findings of the Inspector General. Let's see here. But there's an addition that, that we'd like to just put on the record here. This is our subcommittee putting on the record that the BWC shows indicates that the officer stated, BWC states, Ms. Williams stated that she asked the officer multiple times to obtain insurance information and was told by the officer that it would be in the incident report. So that was on the BWC. So the officer told her that he would do that, and then he did not. And during his interview, the officer confirmed that he took a photo of the driver's insurance information with his division issued cell phone. And then he stated, officer stated that he did not think it was necessary to include the information in the report. And we agreed with the IG because in this type of call, he did not violate policy or procedure. However, he stated in the report, on BWC, and he told the complainant that he would do that. And we thought that that was unprofessional to do that. And two more. 2024-1606. This is an allegation of misconduct. The complainant alleged the officer did not conduct sobriety test on someone that appeared impaired. So the IG reviewed CAD material, BWC footage, and policy and procedure. In regards to allegation 1, the investigation revealed the officer followed policy for a call for service involving an auto crash, property damage only. The officer determined that there were no indicators of impairment and was not required to conduct field sobriety tests due to lack of these indicators. Therefore, it is recommended that this be closed as exonerated. We reviewed this and we agree with the findings of the Inspector General. The officer's BWC footage showed no signs of impairment on this individual. He indicated no odor, after sitting, he had the individual sit in his vehicle for a period of time, and he indicated that there was no odor of alcohol, et cetera. So we agree with the Inspector General. The last one is 2024-1615, and this was another misconduct and another auto accident. The complainant alleged, 1, the officers did not complete field sobriety test even after the woman admitted that she had been drinking. 2, the officers did not complete a report, and the officers did not arrest the woman, and the officers did not verify exchange of information. The investigation was conducted with the use of CAD, BWC, and review of policy. With regard to allegation 1, sobriety test, let's see. The officers, the investigation revealed that the officer followed policy for a call for service involving auto crash, property damage only. The officer determined that there were no indicators for impairment, and he was not required to conduct field sobriety tests due to lack of indicators. The at-fault driver did not admit to drinking. Therefore, it is recommended that this allegation be closed with a finding of unfounded. As to allegation number 2, the investigation revealed the officer followed policy for a call for service involving auto crash, property damage only. Officers are not required to take a report for this type of incident unless there are mitigating, factors as listed in 10 code response. These officers determined that there were no mitigating factors. Therefore, it is recommended that this allegation be closed with a finding of exonerated. Let's see here. Okay. With regards to allegation number 3, the investigation revealed there were no grounds for the officer to conduct an arrest. The officer followed policy for a call for service involving auto crash property damage only, which is not an arrestable offense, without mitigating factors. The officer determined that there were no mitigating factors to conduct an arrest. Therefore, it is recommended that this allegation be closed as exonerated. As to number 4, the investigation revealed that the officer provided the vehicle owners with exchange of information form as required by policy. The officer verified that the driver's license status of the at-fault driver, of the at-fault operator is as required, but is not required to, by policy, to verify the exchange of identification information form. Therefore, it is recommended that this allegation be closed as exonerated. We did review this case, and we agree with the findings of the Inspector General. I think there were 2 cases. Excuse me a minute. I need to find the one more case that had the, Thank you so much. Okay. All right. As to case numbers, we move to accept the findings of the Inspector General as to case numbers 2024-1322, 1388, 1419, 1449, 1487, 1528, 1546, 1595, 1606, 1615. Those first.
May I have a second, please?
And then as to case numbers.
Oh, hold on.
Oh.
Any questions or discussion on any of those? Okay, all in favor, please raise your hands. Okay, motion carries.
Then as to case numbers 2024-1441 and 2024-1466, we move to accept the findings of the Inspector General as to the original allegations.
Okay, may I have a second? Any questions or discussion on those 2? All in favor, please raise your hands. Motion carries.
And then move to accept the findings of the allegations of the Inspector General.
On 1441 and 1466.
Yes.
Okay, may I have a second? Second. Any questions or discussions? All in favor? I got you. Motion carries, thank you. All right, so at this time, we will go into, unless anyone would need a break, we will go straight into any kind of policy discussions or questions that any member would like to put forward.
I had a question that our committee asked the Inspector General's office. It had to do with a case that we handled back a few months ago. The case involved an officer who's using his Facebook. The account is called Thoughts of a Patrol Officer, and I wasn't sure what the meaning of the Inspector General's response was, so I was just confused with the finding of the Inspector General in the original case, and then we wrote and we asked. This was a case in which it wasn't clear as an initial matter what department the officer worked for. It was just a patrol officer. The complainant initially thought that it might be that he worked for Cincinnati, I believe, checked down there, then discovered that it was, in fact, Columbus. And the investigation revealed the officer doesn't specifically identify as a Columbus police officer. And so it was recommended that the allegation be closed with a finding of unfounded. And so I was trying to square that finding with the last month's case, in which last month, you'll recall, there was a complainant who wanted to withdraw the complaint. You said, we're going to push ahead anyway, investigate, and because there was an objective failure in this case, and it didn't matter if the complainant withdrew their complaint, there was still a problem. And so my colleagues agreed with you. In this case, I wasn't sure why you didn't follow the same logic. Push ahead with the investigation. We now know that the officer is part of the Columbus Police Department, and investigate whether you believe there was an objective violation of Columbus policies and procedures, and say that we think that these Facebook posts was conduct unbecoming of an officer, and not close the case. So I'm just trying to reconcile the two findings.
What I'll say is I know I got the question, and it was attached to a case. So the case that it was attached to, we did open it up and we did a finding. So I wasn't sure. I think I sent a message back to say I wasn't sure maybe the.
Maybe we had the wrong case. No, I don't know if we did. But it was the case involving it was fairly notorious in terms of its background, that the officer was calling it thoughts regarding, what was it?
Thoughts of a patrol.
Thoughts of a patrol officer. And so, yeah.
What I'll tell you is, even though I read every case, I may not remember the different details of every case, so it's important for me to be able to read that case, to be able to provide a comment as to why. So based on that case, and I do know we've received several cases involving this particular officer, and so we've investigated several cases. So I really am not familiar, but if you would forward that to me and give me the specific case that you're talking about so that I can actually look at the case, then I will be able to provide you some feedback. I know that I did add there, because cases, when we withdraw, if someone files a complaint with our office, and we reach out to get information, and they don't provide us enough information to proceed, and they request to withdraw it, then we do withdraw, because we don't have enough information to proceed with an investigation. So there are reasons why, but
Okay.
if someone.
In this case,
This case is a
was
little
different.
different.
Yeah.
I
Okay.
think this case is a little different, and I think what Pastor Nathan is trying to say is basically use that same energy. So basically, when there was the previous case and you decided to move forward with the investigation, even though the complainant decided to, they asked for us to withdraw, they withdrew the complaint and decided, but that investigation still moved forward, just because of, you still noticed that there was a violation and whatnot. What Pastor Nathan is basically saying is, when this case came up, there was a complaint. It was initially thought that it was a Cincinnati officer. Further investigation revealed that it was a Columbus Division of Police officer. Still, what was posted was basically egregious and concerning for some. And so still, the question is, why didn't you still move forward with that investigation? That same energy that was used previously, use that same energy for this one. I think that's what you're trying to say.
Yes, and that it wasn't based upon, by the logic that I was hearing last time, it didn't matter if the complaint was withdrawn. You found an objective violation, decided to push forward and sustain the allegation against the officer. In this case, what we're asking is why you didn't investigate, find an objective violation of CPD policy as conduct unbecoming to an officer and sustain the allegation.
So again, the case that you gave me with the information that you provided, we did investigate the case. It was not withdrawn. So again, I'm confused if you can give me the case that you're specifically referring to, because the case here, 24045, we did conduct an investigation. The information that was provided to us was enough for us to open the investigation. And we did have some findings on that regarding the officer's actions regarding policy and procedure. So maybe I'm just not understanding, but I know we opened that case. We did conduct an investigation. It wasn't withdrawn.
I think there might be some confusion over which case specifically.
Which case it was,
So I'm
yes,
going to
exactly.
find the exact case
Yes.
number, so.
0405, maybe?
I mean, that's the one that was sent to me in the mail, and that's the reason why when I responded, because I got what the question was, but I was confused because we had opened it up, we had investigated it. So if there's another case that
Yeah,
you're
there might
referring
be.
to. Yeah, just send me that case so I can look at it and be,
We were just trying to reconcile the two approaches of the DIG's office and,
The first one is 0405. That's from this most recent one. And then the one prior to that,
And just for the record, 0405 was sustained.
correct.
yeah, but there's another one
Yeah.
that was not sustained, and the reason given was it, at least in our minds, was in direct conflict with what we were hearing last time at at our board meeting.
and I was trying to provide some clarification, so I would ask, just send me the case so I can look at it. I mean, the standard for the Inspector General office, and not just this Inspector General office, but all Inspector General offices, because I belong to the Association of Inspector General, is that we hold any person, if we have jurisdiction here, we have jurisdiction over the Columbus Police Department. Some offices have jurisdiction over other city agencies. So the accountability is that if a complaint is filed, and we're looking at that complaint, and there's some type of investigation that is done when we're initially looking into it, and we find that there is a violation, there's an obligation to report that. There's an obligation to investigate that.
Looking
Right.
for in this case, but we'll try to find the correct.
Oh, yeah, and I appreciate that. What I will say, we can't investigate complaints where there's no information for us to proceed, which usually is the reason why, if someone requests that
Gotcha.
it be withdrawn,
Yeah.
we withdraw it.
Yeah, in this case, there was information about the Facebook posts. We were suggesting that we found them unreasonable, that it was conduct unbecoming, the posts were egregious, but we need to get the correct case number.
Yes, thank you.
Chair Burns and I, we're cross-referencing our notes here. So 0405, that actually was sustained. And that's the one with the post that we asked the question on. And then the one previous to that was 1434.
Okay, and what was that?
That one was the one with the complainant that withdrew the complaint.
Okay, there was, yeah, we'll have to look back. There was in one of the cases regarding the Facebook posts, it was not sustained, but I don't remember why. Okay,
We'll send you an email about that.
I appreciate that, yeah. And I'll definitely follow up. And we can kind of look at, because the posts tend to involve one specific officer, so we can kind of look and see what other cases we've kind of looked at involving that.
happy to jump in here. Not on this particular subject. But of course, if folks find those further details, feel free to jump in. This is more so in terms of kind of the board operations and how we operate. One, I just want to again commend the Department of Inspector General's office and all the investigators for just the tremendous amount of time and energy and work that you all do. It can be thankless work often, but it's really important. I want to highlight and reiterate that we as a board appreciate that, but then also to continue to reiterate our appreciation to the residents of Columbus for the work that you do. You know, as we've been doing a lot of the research about as I've been doing a lot of research about inspector generals across the country, review boards across the country, many of them operate in a variety of different ways. And really, one of the questions that we're trying to wrestle with as a board is how we can more efficiently and effectively do the work. You know, and one of those issues, you know, we have currently, and we've talked about it before, but a 99% or so agreement rate with the Department of Inspector General. It's very high. Again, it's something that I think says something about the nature of the work that you all are doing, the thoroughness of the investigations, and then the process by which we've been able to navigate through reading those cases. But in terms of the way in which, as a board, that the current process works, and for folks who may be watching online or here in the audience who may not know about the process, is that we get the thorough investigation by the Department of Inspector General, does the review of those cases. You send us those case reports, and then our subcommittees have monthly meetings where they review those cases, and then they will talk about you know, whether they agree or disagree with those findings, and then they bring those to this full board meeting, and then we go through the process that we just went through, which is a full read and review of the cases. And while it is quite thorough, and I want to be very clear, at the same time, I don't necessarily know if it is the most efficient way for how we as a board should operate. And I'm still wrestling with different ideas and what that might look like. And one of the important aspects that I really appreciate with Chair Burns is setting aside this time for kind of policy review, policy discussion, and really thinking about where we can spend more of our energy and time in terms of looking at patterns, practices, and trends, because you know, we can continue to reiterate and make this process more efficient, and we have done so over the last several years. And the next phase, though, is really around transparency and making this more accessible to residents. And this is probably something that goes beyond the purview of the Department of Inspector General and is a broader question with the city of Columbus, the mayor's office, city council. But is this idea of having a public database, an online database that individuals, residents of Columbus can access and see and track real time whether they have a particular complaint or what this data that you provide in these quarterly reports, monthly reports, annual reports. And you know, we've talked about this a few times, and I don't know if there is if there comes to a point in which we make a more formal resolution or something, but I do think that it's always a question about resources and capacity, and so as a board, what can we do to advocate for those resources so that we make this more accessible to the public? Because I think, and I don't know if there's a timeline on that of what that would require, but ideally we could get something up and running this year, if possible. And I think it would be a major accomplishment to see, obviously, for folks to be able to access this. I know in places like Chicago, New York, elsewhere, they have this data online for people to readily access. And so I'm not sure the steps that we might need to take to get there, but that's one of the steps that I think would facilitate some of the process here of us going through our case readings.
I just like to ask the question, just so I understand, what kind of access is it that you want the citizens to have on this, the database that you're talking about?
Certainly.
I know they are able to request anything from the
Public
Open
records.
Records Act, and I know that we do post on there. We let the citizens know when the complaint. We let the
It's
citizens.
dramatic. Thanks.
We let the citizens, so I just want to
Yeah.
understand what it is that it is that you want them to have access to, because we have to be, I guess, also careful about the Public Records Act, but can you just tell me exactly what it is that you want them to be able to go to the website and be able to pull up?
Yeah. So I think if, and again, I don't know the data and tech aspect of this and how to do this, but I think it would be helpful if you filed a complaint, you had a complaint number or however they might track it, you also have the ability to go online, enter your complaint number, and actually track the status of your complaint. And so I know right now it's kind of done through kind of email exchange or phone conversations with folks, but I do think that if we can get to that point, that would be helpful, especially as, future iterations of this board and future, evolutions of Department of Inspector General's office. Like, what are processes that we can actually have that where they just log in online, they can access and see the status of their complaint, whether it's in review or if it's at the board, wherever it might be. And I think that would be helpful. Additionally, reports are posted, and that's helpful. So certainly having reports posted online. And then as a board, this is where the conversation about patterns and practices would go in, which is, what are some of the trends that you can find and see. And currently, I don't know if we do this, but a consideration is perhaps precinct or neighborhood or area where complaints are coming from, so that you can start to see potential trends or any patterns. That's something that I think might be worth considering for us to actually include in an analysis. And then lastly, I would just say something available for, and again, understand the aspects around public records, I also understand privacy concerns, but something along the lines of where you can see numbers of allegations or sustained allegations, whether it's, I don't know if it's specifically around per police officer or if there's another sort of reference number. And then the last point on this is the cases in which there are departures from Department of Inspector General and the Civilian Review Board to the to CPD, and they make a departure. And I know that can be found, right? But currently, if you're a resident, it's not readily accessible. And so, and there's reasons for that in terms of constraints and capacity. But I think if we can get to a point where that is readily accessible and available, then, as a board, when we're reviewing these cases, like, we can also point to, a summary, for example, of a particular case number that they can just access online. That would be helpful, I think, in terms of just making this more accessible for residents.
And we are working, I can tell you, this year we're working on trying to do a brief summary in the report. We're trying to, as time goes on, we're trying to just kind of hit those markers because we have more information and we're able to kind of review, and to your point, as far as reviewing what information we have and looking at patterns and things. We're actually doing that right now. So right now, we're just trying to see based on how many officers. There is some information that the board did request. We did forward that to you, and you'll notice that we were able to add the precincts in there.
Yeah.
So, we're definitely trying to make sure that we're providing more information that's available to us that we're able to put into our system.
No, it's super helpful. And then I did have a question in terms of at what point, in terms of whether it's city council or the mayor's office, in terms of resources, the types of resources that would be required to build out a lot of this. I know you all have added capacity through getting some support around data, but are there other steps we can take as a board that might be helpful.
Well, just,
Would we have to ask someone to give the IG's office additional budget money, additional funding, or things like that to be able to do some sort of publicly accessible database?
yes, because we serve at the pleasure of the board. What we can do is, once we're able to, I would just say, specifically find out exactly what the board is looking for, and then do the research to find out what the cost would be to have that, the personnel, what type of cost it would be to, once we're able to put that on the board's website, what it would look like to maintain that. I do know that the beginning of last year, we were working with the other agency, was that Office of Violence Prevention, because I believe they had a grant. They had a grant, and they were trying to put together a database that would have a lot of information, not just from them, but from other city agencies. And they had reached out to us, so we can definitely follow up with them. We do talk with them occasionally, but we can follow up to see where that might be, because if that was something that they were going to sponsor and we were just going to provide them data, that would be great to be able to do that.
That's great. So we can follow up with that in terms of what maybe the details of what this could look like. And I don't know if other board members have ideas or things they would like to see in something like this. And then if you all maybe are able to do the research into cost and what that might look like, that would be great. Thank you.
Related to the question of transparency and access, I just looked up in my email to see when we did it. I think it's been 2 years since the board made a request to City Council to have our committee meetings be virtual. I have made repeated contacts about that, and so I'd like to enlist some assistance from some others to see if we can get some movement. My reasons for that are our committees do most of like the in-depth discussion about these cases. However, they are not held at times that are really convenient for members of the public to be able to come and access and to hear about what are the in-depth questions that are being asked about their cases. And so I never got a definitive answer back that said, no, we can't, and did not get any real response about how can we move that language forward or what were the holdups. So I will let Mr. Tobias speak because he leaned forward in his chair. So I'd love to hear any updates, if any, that anyone has about
Your timing
our
is
possibility.
impeccable.
Great.
So I have in front of me House Bill 257, which the state legislature passed recently that will, I think, go into effect in April. It talks all about virtual meetings. But right now, I think it excludes city council in terms of virtual meetings, but I printed it so I could read it. I haven't read it yet. But my basic understanding is it's going to allow boards, commissions, other city entities to have virtual meetings. The problem is that it may conflict with the city charter, because the city charter affords council the authority to decide what city boards, commissions, agencies are allowed to have virtual meetings or not. So there may be a preemption home rule issue here that we're going to digest. I have a general council meeting on Monday where this topic's going to be discussed. I have some homework to do before that meeting, so stay tuned, because it's out there now, and so we just have to figure out. I don't know whether city council will consider an amendment to the city charter, whether it will be something statutorily done in terms of how it will affect local boards and commissions. But I will definitively say, as of right now, no virtual committee meetings.
Well, thank you for that update.
I will be sure to email you an update after we have our discussion next Monday.
No, perfect. And if anyone else wants light reading, you can go ahead and find House Bill 257
I
as
was
well.
going to say,
It's not
all
that big of a
things
bill.
considered, it's only about 10 or 15 pages.
Yeah,
It's
that's
pretty
not
thin
bad.
compared to other stuff I've read, so.
Yeah. All right, thank you for that.
257, House Bill 257.
We did check that case. The confusion was on my end. There were two allegations, one of which was that he had posted that he was a Columbus police officer. That apparently he did not, and that's what that was the conclusion of unfounded by the DIG. So that's what I was proceeding on. It's like, why would you have found, concluded that it was unfounded? There was a second allegation that was sustained, so.
The second
That was
allegation
the same
regarding
case.
The post and the content of the post. So yes, got it clarified.
No, that's fine. And that was, I believe that was the same case, right?
Yes.
All right, any other issues that folks would like to have on tap for discussion?
Yeah, I don't know if there's an opportunity, maybe for you as the chair, or somebody from the board or the Department Inspector General to actually do a presentation at some point to City Council about an update, whether on the findings of the board and the process of the board. I think that would be helpful. I don't know how to facilitate that process and what that looks like. Obviously, you'd be invited to it. You can also show up and offer your testimony if you'd like. But I think that'd be a good opportunity. City Council plays a role in this process. They certainly played a role in the beginning of the board. I think it's varied throughout the last several years, but especially considering some of the ongoing public safety discussions. There's conversations about alternate response models and crisis responses. I think more collaboration and involvement with City Council, I think, would be helpful and useful. So that's one thing I wanted to put out there. And then lastly, kind of relatedly, is the process for appointments. I understand it's outlined, in the charter there about how we move the appointment process forward. I know we also have a new person joining the board, so excited to have you. I think my concern about the way the appointment process has worked, and I know there's a lot of reasons for it, capacity, trainings, people that go through the process, but my concern is that future iterations of the board, the way in which we've navigated this process, I don't really know what the backstop is for, let's say if there were just no appointments made. I'm not saying that we're there and that hasn't happened yet, but there isn't really anything in place if just this process that's vacancies were just left open. Is that my understanding, or is there other?
What's happening with this board is not unique to this board. It happens all across the city. I'm familiar with plenty of other boards that have 2, 3, 4 vacancies and openings for long periods of time because they're the administration are engaging in efforts to solicit people to serve, but they can't find people, or they find people who ultimately wind up changing their mind or are not qualified to serve in some capacity. So, yeah, the code doesn't speak to this, what do we do if we can't fill seats? I mean, obviously on an 11-person board, ideally it's great to have every seat filled, but, if you have 4 or 5 people, that would probably be a little bit more problematic than if you had 8 or 9 going for a couple of years. That would probably require somebody to light a fire under somebody higher up, to get things moving. But I don't think, at least for this board, I would feel comfortable saying you're not in crisis mode.
Certainly, and I appreciate that. I don't think we are in crisis. I'm just more so thinking future iterations of this, where you could be in this situation where you have these vacancies for long periods of time, and the steps that we can take as a board, perhaps, or the steps City Council can take, to support the administration in its efforts of soliciting.
So the other thing that I'll say is, I recognize that the requirements to serve are onerous. They're statutory, but they were from inception, right? So now that you've been doing this for a minute, if you realize that there's a way to modify the requirements in a way that's still meaningful, you don't want to just set them all aside.
Yeah.
Obviously, they're important, but in some way amend them in a way that they're more, I'm trying to think of the right word, like compacted or,
Yeah.
or combined, so that the training requirements are not as onerous on folks. Because that could be a deterrent as to why people don't want to do it, because it takes a period of time to do that. Code changes obviously are a little more challenging because you got to get everybody to have an appetite, city council to have an appetite for that. But, if as a board you decide that you put together a draft and want someone to take a look at it, I'll certainly take a look at it.
Okay, yeah, we can get to work on that. Thank you, appreciate that.
If I could go back to the update for city council. Ms. Ross, do you know the process for getting in front of council? And I'm asking because knowing that our annual report is going to be produced soon, that might be a good opportunity for more than like the 3-minute comment, but to be able to present, yes.
Are you talking about presenting for purposes of the report or for purposes of asking for money?
Oh, I was just meaning the report.
Okay,
Just
good,
the
because I was
report.
going to say, if
Okay,
it's the
good. I was like-
latter,
like,
that's
we
not
missed
how
the
you do
budget.
it.
No. Just for the sake of kind of putting out there and presenting, like, here's what the IG's office has been doing, like, here's what we as a board have been doing, like that sort of thing, to put it back into like a public setting for conversating and answering questions if they have any.
That's a great idea.
My response was going to be, it should be a departmental ask, and I know that the IG has done this before already, so I'm going to defer to the process that she has already taken or has already at least researched a little bit, and I think you can do it together.
What I can say is we have done that, especially like our first year. And normally the process is we just reach out to city council and make a request. I'm glad that you had, that the board is interested in doing that, because we're preparing the annual report, and I know we've had some conversation. We're going through Stephanie, and I know she's going with the board. Stephanie would have been presenting, but I'm sure Stephanie was like, she will gladly give up what she was going to be presenting on behalf of the board. Once the report is final, the plan was to finish the report, bring it to the board chair for the chair to review the annual report to see if there was some additional information that was not reported by the board that the board wanted to have on that report. Then the goal was to present the annual report to the board because we serve at the because we're a part of the board. And then from that, once the board was able to get the report, would be to reach out to city council and then present it to city council. So, yes. And I can tell you the process that we've always been doing is any of the reports we've done, the quarterly and the annual reports we've done over the years, we always make it a point to present it to the board first. And then we have followed it up by sending it out to city council so they are aware. But that's initially what we were going to do. But again, yes, we would love for the board to be able to be a part of presenting that information.
Thank you. All right, any other issues for the good of the order?
Just a plus one, not an issue, but in addition to this is, in addition to the city council report, thinking about working with the community engagement folks and community outreach as part of a series in terms of having additional rounds. And then my proposal from like a year or 2 years ago of having one of these board meetings, a regular board meeting at a different place in the community at some point. Not sure when, maybe some point in the summer, we do something at a rec center or somewhere else, is something that I think we should consider. Maybe a different time. Definitely a different time.
All right, anything else? Okay, seeing none, I would entertain a motion to adjourn. May I have a second? Second. All in favor, please raise your hands. All right, motion adjourned. Thank you all.